contract which is awarded has to be the one which no suitable tenders were received for. So, you know, I think that probably means the same thing anyway. Under the bill, the contract can only be awarded to a supplier which is not an excluded supplier, and that's a supplier which mandatory exclusion grounds apply to. That's actually the case for all of the direct award justifications under the bill, but Lynsey's going to talk about that a bit more later on. And the bill also requires authorities to consider whether the supplier is excludable, so whether a discretionary exclusion ground applies, and also whether they submitted an unsuitable tender in the original process. It's not really clear what that means or how, you know, they're supposed to take it into account, but I think authorities would need to be careful when awarding a contract in these circumstances, particularly if there's been other tenderers who'd also submitted unsuitable tenders, or if you're changing the requirements in some way. So the next ground under the regulations is Regulation 32(2)B, and this applies where there's only one supplier who can make the supplies. It applies to goods, works or services where there's only one supplier, either because the aim is to create or acquire a unique work of art or artistic performance, or because competition is absent for technical reasons, or if the supplier has exclusive rights, such as intellectual property rights, but these only apply if there's no reasonable alternative and there hasn't been any artificial narrowing of the market. There's surprising little case law on this, but it's really intended to be used where a competitive process would result in only one suitable tender anyway. So, you know, just from the one supplier who could meet the authority's requirements, and obviously the intention is to avoid the wasted time and cost of the procurement process to get to that result. In relation to art and artistic performances, then I think authorities probably need to think carefully about whether there is really only one supplier. You know, if it's for a high profile important event and the artist is internationally renowned for that specific type of art or performance, then quite possibly, you know, there may only be one supplier. But if it's anything less than that, then it probably is achievable by more than one supplier. You know, and authorities do need to think carefully about the requirements in relation to this, into all of these grounds for single suppliers, because you can't specify a particular design or product which only one supplier can provide if actually other designs or products would be equivalent and meet their functional requirements. You know, there are kind of restrictions on what you can include in your specifications, and you need to be thinking about functional requirements rather than specifying particular products ideally. Technical reasons is quite broad. It might be if there's only one product that would work with the existing equipment, or if there's only one supplier has the know-how to be able to achieve what's wanted, or even possibly if only one supplier has the capacity to meet the demand that's required. However, you do need to be careful not to confuse technical reasons with economic reasons. The regulation does confirm that competition needs to be absent and not just more expensive. And if there are technical reasons why only one supplier can supply what's needed, then I think you probably need to be documenting those carefully. I won't say a lot on exclusive rights, as it's usually fairly obvious if there are exclusive rights or not, but the issue in relation to that is really whether there's been a reasonable alternative or an artificial narrowing, and that comes back to, again, thinking carefully about your actual requirements and not defining them too narrowly. In a lot of cases, the exclusive rights are probably linked to the technical reasons anyway, because the exclusive right holder will have the rights to whatever is the right technical solution. But obviously think about whether that product has been licensed. You know, the IP rights are licensed to someone else, so there is more than one possible supplier who could be appointed. But the real question, I think, in all of this is, how do you know actually that there's only one supplier if you've not been to the market to find out? And I think the EU authorities do suggest that there needs to have been some kind of research into the market. You know, you might have done some pre-market engagement, or there may have been a previous opportunity that's advertised that didn't get any responses, and authorities shouldn't just make a bare assertion that there's the only supplier that can meet their needs. In terms of the bill, that is almost identical, but there's now no reference to artificially narrowing the market. But I think that's probably because the requirement for no reasonable alternatives achieves the same purpose really anyway. Moving on to extreme urgency, which is obviously the one that has received a lot of press in recent years because of COVID and some of the decisions that Lynsey referred to earlier. And this is at Regulation 32(2)(c), and there are actually quite a few requirements which need to be met for this one. Firstly, it only applies so far as is strictly necessary. And this really means that the authority should only direct toward a contract which meets their urgent needs and gives them time to go through a proper process, because they should go through that process to secure any longer term needs. It only applies if there's extreme urgency, and I think the word extreme probably relates to the reasons why something is urgent. You know, what happens if the supplies aren't obtained within a short period of time? Is it a matter of life or death or property damage? You know, think about whether it really is extreme or not. And the test in terms of timing is whether the time limits for an open, restricted or competitive procedure with negotiation can be met or not. And obviously you need to remember as well that there are accelerated procedures that are available, but in addition to the specific time periods that are prescribed in the regulations, you also need to factor into the other time that is needed to prepare for the process and to consider the tenders that are received. So you're really looking at how long the process would usually take for a contract of that specific type, and obviously it will vary depending on the factual circumstances. The urgency has to have been unforeseeable by and can't have been caused by the contracting authority. You know, they can't rely on their own failure to start a process in good time to say that the contract is now extremely urgent. Obviously, that can leave an authority in a difficult position where they haven't left enough time. There is an interesting Scottish case on this relating to rock salt, where an authority got caught out one winter and was justified in making a direct award, but then the following year they weren't justified because they should have learned from their previous experience and planned properly. And there are a few similar EU cases too. And then obviously, as I mentioned, there's been the COVID cases and brought by the Good Law Project. And they do actually suggest that the courts will give quite a bit of leeway in deciding to an authority in deciding whether something is urgent or not, and deciding how far they need to go in terms of what's necessary and to what extent they should try to comply with the rules, even if a direct award ground applies. But just be careful on this, because if a direct award ground does apply, but you nevertheless follow some kind of competitive process, then you should still be complying with the principles of equal treatment and transparency. And obviously that wasn't the case in the notorious VIP lane that was adopted by the government. The equivalent provisions are in Schedule 5 of the bill. They've played around a little bit with the structure of the wording, but it's basically the same again. The next ground is at Regulation 32(5)(a). It's in relation to, it applies only to contracts for the supply of goods and where those products are manufactured purely for research, experimentation, study or development. And it does expressly exclude contracts for quantities which are designed to assess commercial viability or to recover research and development costs. So it's very clearly just the first stage of developing a brand new product. It doesn't really deal with what happens next. The bill's different in that respect because it does expressly allow production at scale to assess viability, and it's also wider as it allows a direct award of service contracts as well as the supply of goods, and that's probably because of things like software contracts obviously can be require a lot of research and development. The next is Regulation 32(5)(b), which applies again only to goods, but which will also be extended by the bill to goods, works and services. It applies where an authority needs more of the same product as originally supplied, either to replace what was originally supplied or because they need more of the same. Excuse me. And we're getting the supplies from someone else would mean that the products had different technical characteristics, which would result in incompatibility or disproportionate technical difficulties in operation and maintenance. In practice, it's probably likely to apply in similar circumstances really to the technical reasons and exclusive rights grounds. But as a test is proportionality, then it's probably slightly easier to meet. Although it does talk about proportionality in terms of technical difficulties, but I think really it's likely to come down to cost, because the more technically difficult it is to alter a system or a different piece of equipment so that a different part can be used, then the more it will cost. And currently the contracts can only be for a maximum of 3 years, but this is removed in the bill. And otherwise the bill is very, very similar, but we've lost the reference to different technical characteristics, but I don't think that really added anything anyway to the question of whether there were disproportionate technical difficulties in operation or maintenance. I think that they're both the same point. So I'm going to hand over to Lynsey now just to deal with the last few parts of the regulations.
Thank you, Kathryn. I'm just going to, there's just a couple of extras under the existing ones and then some additional stuff from the bill. So another exemption is this or repeat supplies justification, and at the moment that's under regulation 32.9 of the public contract rules. This is where you've got to supply similar works or services by the same contractor, so it's slightly different from the previous one but similar. So effectively you're looking at was whether it's in conformity with the basic project for which the contract was awarded under the PCR compliant award procedure. So you're kind of trying to look and see, well, is it effectively the same thing but a repeat of the original? And you're looking at the extent of the conditions for and estimated costs of the subsequent supplies disclosed in the initial tender document. So running through this and through a theme of the current regulations and the bill is this idea that if it's effectively the same thing and you've already had your competitive procedure, there are exemptions to allow you to effectively continue contracting, but only in certain circumstances and where you can see from the initial tender documents that might happen or that the intention is there. So under the current regs, this is within 3 years of the initial contract, so you've got a window within which you can do it, but you can't kind of do it indefinitely. Under the bill, it's kind of a similar provision, but it also includes goods, whereas the one under the current regulations doesn't. The language has been simplified to some extent, and it now talks about it's an existing product or goods, works or services are supplied following a competitive tendering procedure. So again, you've got the check there that there has been the competitive procedure in the first place. And then again, the initial tender documents need to set out the intention to carry out the subsequent procurement and informed information required by regulations. I'm trying to say. But what they've done with this change is they've expanded the scope of the time-wise as well. So this is the initial contract needs to have been awarded within 5 years, ended on the date of the transparency notice. So I'll come on to transparency notices, but what that's effectively saying is you've got a 5-year window from when you award the new contract and issue a transparency notice to say you've done that, looking back to when the first contract was entered into to say whether it can fall with under this exemption or not. Another couple of quick ones that are under the existing regs and the bill. We've got the supply of goods on the commodity market, which I won't go on to, but it's general trading. And then you've also got the supply of goods and services on advantageous terms from a supplier which is definitively winding up its business activities or is in insolvency. And at the moment that's under regulation 32.5D of the public contract regulations, and is very much designed for a fire sale where you're buying from the supplier that is becoming insolvent, like definitely becoming insolvent, so that so effectively that the public body can take advantage of that without having to go through a procurement process that wouldn't be suitable. In the new bill under Schedule 5, this is paragraph 11, and this is again supply of goods, works or services. So we've got works added in there, and it's on advantageous terms, and it's due to an insolvency procedure. But whereas previously it had to be a definite winding up, now it's just something it's just where a supplier is undergoing an insolvency procedure. So it can even be where a petition for winding up has been presented, or where some kind of solution for solvency being presented rather than definitely being followed through. So that's new. And then the other change is that it can be awarded to any supplier. So it's not necessarily that you're buying directly from the entity that is becoming insolvent. So that seems a bit wider as well. Whether that will make it through to the final bill or not, we'll see. So what's new under the bill? So we've talked about what is existing. These are new provisions that have come in, and a lot of these you can see kind of politically and from recent history where they've come from. The first biggie really is this protection of life justification under Section 42 of the Act. And this effectively allows a Minister of the Crown Secretary of State to produce secondary legislation, so regulations that allow them to award contracts in certain circumstances. And it has to be where it's necessary to protect human, animal or plant life, or it's to protect health or to protect public order or safety. So it's very broadly drafted, but in general, it's obviously designed for the kind of emergency circumstances where it's not just one particular emergency contract. It might even be something foreseeable, but it's a situation where there is a need to go beyond the usual contracting rules to put in place something in particular. There are some kind of safeguards on this, and the idea is that it's whenever the minister decides this is necessary, which again gives them a bit of scope. But then kind of says, well, you can set out how you do that. So you can say it's a specific type of contract, or they can say it's a class of contract, or they can say it's by reference to a particular purpose or subject matter. So for instance, with COVID, you could see that could be used for that. You could say, it's for this specific purpose to do with COVID, but it doesn't say that the minister has to do that. It can also just give a general discretion. So you can see that whilst there are some protections in there to give you an idea, it's actually relatively broad. There is a duty under the ministry who puts in place these regulations to keep them under review and to revoke them if they consider them they're no longer necessary. There is a kind of proposal or an amendment to potentially limit that to a 6-month period, but that at the moment that hasn't gone in, so we'll see what happens on that. Effectively, you've got these new justifications or the new justification, and then you've got the changes to the bills, and then you've also got some additional kind of rules that sit around these things, generally around transparency, but also protection. So Kathryn mentioned earlier this issue of whether you can award direct contracts to excluded or excludable suppliers. And there are some provisions on that. So where you've got a direct award to, you've got the justification under Schedule 5, you can't award that to an excluded supplier. And under the public contract regulations and under the bill, there are grounds upon which you must exclude certain contracts, but then also grounds upon which you can or you may exclude others at your discretion. Where you've got someone who's an excluded supplier, so wouldn't normally be able to contract, you can still contract with them where your contracting authority thinks there's an overriding public interest to do so, under Section 41, 2 and 5 of the bill. And it sets out there, what kind of things does that mean. So in terms of the overriding public interest, you've got these kind of these categories of, where the contract you need is in relation to the operation and maintenance of a critical infrastructure. So is it required to keep the critical infrastructure of the country moving? Is it a function of defence or security or economic stability? Is it required for that purpose, or is it required for military or security purposes? Or in addition, is there just extreme urgency? So again, you get this kind of overlooping lap between some of the provisions and how they operate. Even when you're in these circumstances where you've got this kind of emergency situation and exclusions, the authority can still undertake some kind of selection process or other preliminary steps. That seems to be designed to say, well, you might have the extreme situations where you may still have more than one contractor and want to carry out a direct award. So there seems to be some provision to be able to do some kind of selection or preliminary steps towards that if you feel the need to. You don't have to just pick one person and go with them. And then overarching all of this as well, you've also got this obligation to consider whether the supplier that you're looking at is excludable. So they might not be excluded, but you need to think about whether they're excludable rather than just assume that they're not. A couple of other relevant changes is that we've got this new provision for a transparency notice. So this is where a contracting authority is awarding a contract under Schedule 5 justifications. Section 41, or where they're switching to a direct award under Section 43. So they have to deliver this transparency notice. So it's effectively where you've got a direct award, but not where you're protecting life under Section 42. And the idea is that you have to issue a notice to say that you intend to make the award and set out some other information set out in the regulations, but the regulations don't exist yet, and it just says before, so there doesn't seem to be a time frame. So you could, it could literally be issued one day, and the contract awarded directly afterwards. So in one sense, it's a transparency obligation because it tells people you have to tell people, but in another sense, obviously, it doesn't give you much of a window to do much about it, because some of the rights that you have to challenge a contract, such as ineffectiveness and setting them aside or stopping them being entered into because you've issued proceedings beforehand, you have a short period of time to do that before the contract's entered into, and you only have a 30-day period to challenge from when you knew or ought to have known that there was an issue. So it's a bit of a mixed bag, that. And it's also not clear how it's going to interact with contract notices, which you have to provide for most things anyway, and which trigger a mandatory standstill period. But for these types of contracts, that's also been excluded. So there's no mandatory standstill period where there's extreme and unavoidable urgency or necessary to protect life. So that's a whistle-stop tour. I'm sorry, we're at 1:30, but we'll just carry on for a couple of minutes. Kathryn, we've got a couple of questions, have we? That you could just.
Yeah, we have. Well, none of them are very quick, I'm afraid. There's some really interesting questions actually. So I don't think we'll get through them all. We certainly won't get to give any kind of detailed answers to some of these questions because they involve quite a lot of interesting. They could probably have their own session in their own rights, most of these. First one that I'll just pick off is, would exclusive rights include a developer's ownership of land which a local authority wants to use for social housing? I think that's a question that gets asked quite a lot, and it is quite an interesting and complex one. Land transactions are obviously exempt from the rules anyway, but if there's some kind of element of development, then it can bring it into the concept of a works contract. So that the exclusive right would be the ownership of the land. I think the answer is possibly that it might apply, but you'd obviously need to look at the facts carefully to see if it does meet the test or not. And I think you'd probably wanting to be taking legal advice on that at the time to see if the facts meet the test. And very quickly, what should a council do if it hasn't left enough time to undertake a procurement exercise? And I think really you'd then be looking to see whether it is really extremely urgent, or whether you do have time to do a process. And if there isn't really enough time, then you've put together as strong an argument as possible to support a direct award on, for extreme urgency, but being conscious that, be prepared for the risk of a challenge. I think I would also look at whether there's any other exclusions or direct award grounds that applied, because obviously extreme urgency jumps to mind immediately from the question, but there might be other reasons why you could direct award or why you don't have to comply with the rules. And also think about whether there's an existing contract which could be modified, or whether there's a framework that could be used in a shorter time frame. I'm sorry to give this answer, but it is quite fact specific. There's no, it's not a one-line answer that can be given on a webinar, I'm afraid. So I think that's all we've probably got time for. There are some other questions. Like I said, there's some really good questions in there that we'll pick up offline, and we'll follow up after the webinar and get in touch with the other people who have raised these other questions.
Okay, thanks, Kathryn. And just to say as well that this is kind of forming part of a series of these kind of updates on what's coming up on the bill going forward. So we will be in touch with follow-ups to that, so that you can sign up for those. We will circulate the slide deck, and obviously if you've got any other questions or anything else occurs to you afterwards, then please do get in touch.
Yeah, and just as well, Lynsey, I thought if there's anything that anyone is particularly interested in a session like this then let us know, because we'll think about whether we can do that.
Yeah, absolutely. Great. Thank you. I'll end the session now.